You believe that your doctor was careless and caused you significant harm and injury. When your case goes all the way to trial, what do we actually have to prove to show that you are entitled to a verdict in your favor? Would you like to know the answer? Come join me for a walk through the neighborhood near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. We have to show a few things, and we do that by having a medical expert, a qualified medical expert, describe that your doctor was careless and caused you significant harm and injury. Now, it's not simply enough for the doctor to say, yes, your doctor was careless, and therefore you're entitled to a verdict. No, no, no. We have to show in exquisite detail that the actions or inactions of your doctor violated from the basic standards of medical care. Now, how do we do that? Well, we have to do that in New York using a medical expert. The medical expert has to review every single page of your record. They have to go through and understand exactly what your doctor did and why. And then your expert has to turn around and say, listen, the standard of care for this type of procedure requires that the doctor do A, B, and C. In this case, it's clearly evident that the doctor did not do A, B, and C. He did instead X, Y, and Z. And in this particular fact pattern, you are required to do A, B, and C, and here's why. And now the doctor will have to explain in great detail why, when doing this particular procedure, you have to do A, B, and C. He will also have to explain that if A, B, and C had been done, you would not have suffered the injuries for which you are now claiming you are entitled to receive money as a form of compensation for all the harms and losses and damages that you incurred because of your doctor's carelessness. Did you know that when we go to trial, we don't have to show with 100% certainty that what we are claiming is true? Now you might be saying, I don't understand that. What do you mean you don't have to show with 100% certainty that what we're claiming is true? Well, in New York, in these civil lawsuits involving claims against careless doctors, against hospital staff, we only have to show that we are slightly more likely right than wrong that what we are claiming is true, which means we only have to tip the scales ever so slightly, 50.01% in our favor, in order to show that we are entitled to a verdict in our favor. We don't have to show that we are 75% right, or 85%, or 90% right, or even 100% right. None of that is required in New York. Instead, we only have to show that we are slightly more likely right than wrong that what we are claiming is true. Legally, that's known as a preponderance of the evidence. Don't think for a second that you require 100% guarantee by your expert. Oh yes, this is the only way this could have occurred. No, 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 that's not what we have to show. If our expert is able to come in and say, yes, this doctor violated the basic standards of medical care, instead of doing A, B, and C, this doctor did X, Y, and Z, and as a result of that, that was a departure from the standard of care that never should have been done, and it is solely because he did X, Y, and Z that this patient suffered harm and injury. In that instance, we will now be able to go to the jury and now say, listen, we are entitled to a verdict in our favor. Why? Because we have shown you, we have proven by a preponderance of evidence that what we are claiming is slightly more likely right than wrong. And as a result, this patient, my client, is entitled to a verdict in their favor. So why do I share this quick information with you? I share it with you because as you're considering bringing a lawsuit, you're thinking, okay, what do we have to show? How do we show that we are right and the defense is wrong? Well, hopefully this opened your eyes to one of the things that's required in these types of medical malpractice cases in New York. You know, I recognize you're watching this video because you likely have concerns or questions about your matter. Well, if you are thinking of bringing a lawsuit but have not yet started a lawsuit, and your matter happened in New York and you still have questions, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.